5 seconds to go. Start. Thereafter, in their presence, the accused should be asked to make an appropriate statement as he may desire in regard to pointing out the place where he is said to have hidden the weapon of offense, etc. When the accused, while in custody, makes such statement before the two independent witnesses, punch witnesses, the exact statement, or rather the exact words uttered by the accused, should be incorporated in the first part of the Panchnama that the investigating officer may draw in accordance with law. The first part of the Panchnama for the purpose of section 27 of the Evidence Act is always drawn at the police station in the presence of the independent witnesses so as to lend credence that a particular statement was made by the accused expressing his willingness on his own free will and volition to point out the place where the weapon of offense or any other article used in the commission of the offense had been hidden. Once the first part of the Panchnama is completed, thereafter the police party, along with the accused and the two independent witnesses, punch witnesses, would proceed to the particular place as may be led by the accused. If from that particular place anything like the weapon of offense or blood stained clothes or any other article is discovered, then that part of the entire process would form the second part of the Panchnama. This is how the law expects the investigating officer to draw the discovery Panchnama as contemplated under section 27 of the Evidence Act. If we read the entire oral evidence of the investigating officer, then it is clear that the same is deficient in all the aforesaid relevant aspects of the matter. This court has elaborately considered as to how the law expects the IO to draw the discovery Panchnama as contemplated under section 27 of the Evidence Act. In the present case, leave aside the recovery Panchnama being in accordance with the aforesaid requirement, there is no statement of Boby, accused number 3, appellant herein, recorded under section 27 of the Evidence Act. We are therefore of the considered view that the prosecution has failed to prove the circumstance that the dead body of the deceased was recovered at the instance of Boby, accused number 3, appellant herein. Another circumstance on which the High Court relied was that the recovery of ornaments was at the instance of Boby, accused number 3, appellant herein. We find that both the trial court and the High Court have patently erred in relying on such recovery. The trial court found that there was enough material to show that the alleged recovery memo was a fabricated document and the alleged recovery as per Exhibit P14 is farce. However, the trial court still relied on the said recovery to convict the accused. In our view, the finding of the trial court in this regard is totally perverse, which has been confirmed by the High Court. Insofar as Shibbu alias Shibbu Singh, accused number 1, is concerned, the additional circumstance so to be relied on by the trial court and the High Court is the alleged recovery of the spade. It is to be noted that the spade was also recovered from the same place from where the dead body of the deceased was alleged to have been recovered at the instance of Boby, accused number 3, appellant herein. The trial court again held that the place from where the spade was recovered was already known from the disclosure statement of Boby, accused number 3, appellant herein. However, it still held the recovery of the said spade to be admissible in evidence. It is thus clear that the said recovery was from a place which was already shown and not exclusively within the knowledge of Shibbu alias Shibbu Singh, accused number 1. We find that the trial court has again committed perversity in arriving at such a finding. It is thus clear that the only circumstance that now remains is the circumstance of the accused last seen in the company of the deceased on the basis of the evidence of PW1. In that view of the matter, we find that solely on the basis of last seen theory, the conviction could not have been recorded. The prosecution has utterly failed to prove that the recovery of the dead body of the deceased was at the instance of Boby, accused number 3, appellant herein. The recovery of the articles from the house of Boby, accused number 3, appellant herein, even according to the trial court, is farce and fabricated. The recovery of the spade at the instance of Shibbu alias Shibbu Singh, accused number 1, is from a place which, even according to the trial court, was also known on account of the disclosure statement made by Boby, accused number 3, appellant herein. In that view of the matter, we find that the prosecution has utterly failed to prove the chain of incriminating circumstances which leads to no other conclusion than the guilt of the accused. Stop.